Thank you, Senator Jackson. Senator Anderson?
I just like to point out that thoughtful bills like this will make him a great congressman.
Thank you, Senator Anderson. Any further discussion or debate?
I will associate my comments with the kind senator. Thank you.
Great. That's your close. Okay. Members, any objection to using the unanimous roll call? Seeing none, ayes 37, no 0, measure passes. Members will move on to file item. Oh, I'm sorry. Excuse me. We're going to take a look at another set of legislation here, starting with file item 48. Senator Mitchell, are you prepared to bring this measure forward? Secretary, please read.
Senate Bill 238 by Senator Mitchell, an act relating to foster care.
Great. Senator Mitchell.
Thank you very much, Mr. President and members. I'm proud to be a part of the package of legislation that I am jump-starting here, dealing with a critical public policy issue that's been addressed in informational hearings, several of which have already occurred and will continue through the interim season, and that's dealing with the notion of psychotropic drugs and their use among our foster care population. Today, I am presenting Senate Bill 238, a bill that will bring much-needed oversight and revise the procedures for the use of psychotropic drugs within the foster care system. Child welfare services social workers rely on experts in the field of behavioral health to diagnose and recommend treatment for children who may be exhibiting behaviors symptomatic of mental illness. Sometimes this regimen of drug treatment includes multiple prescriptions that may interact negatively, and also may include prescriptions at dosage levels that are inappropriate for the age, weight, and developmental stage of the young person. Data is not readily available to social workers regarding the actual medications being taken, rather than just those that are prescribed. And finally, it's important to ensure that the observations of youth and caregivers, as well as social workers, are taken into account in managing the medication process. As these bills have gone through the legislative process, we have heard heart-wrenching personal testimony from current and former foster youth who talk about their experience having been prescribed various psychotropic medications, the fact that they were not consulted as they moved from placement to placement, different drugs being prescribed, the drugs not being tracked, them not being educated on appropriate dosages, or even their rights, whether or not they choose to take these medications or not. What does this bill specifically do? And I will summarize it. SB 238 will ensure that the departments, the various departments, both the Departments of Social Services and the Departments of Healthcare Services, as well as the legislature, are receiving appropriate reports and documentations that we need in order to monitor the youth who really are our responsibility, children who are in foster care. That triggers are in place to make sure these children are not being over-medicated, and that those who are entrusted with the youth's well-being, social workers, court-appointed advocates, their attorneys, receive adequate and appropriate training. The bill goes into specifics. It talks about updating the JV 220 court form. Again, we're requiring record keeping, the development of data, monthly data reports between these two state agencies who have oversight over the well-being of these children. With that, I ask for your aye vote.
Thank you, Senator Mitchell. Members, any discussion or debate? Seeing none. Members, is there any objection to using the unanimous roll call? Hearing none, ayes 38, no 0, measure passes. Now move to the next item, number 64. Senator Bell, are you prepared to bring this measure forward? Secretary, please read.
Senate Bill 319 by Senator Bell, an act relating to child welfare services.
Senator Bell.
Thank you, Mr. President and members. I'm carrying two bills and a package of bills that we just started here to address the issue of overuse of psychotropic drugs in our foster youth. As we know, nearly 1 in 4 children in foster care and an amazing 56% of children in group homes are receiving psychotropic drugs without adequate oversight. And of course, we realize that some of these children warrant some medication, but the state must ensure that these powerful drugs do not replace other effective and necessary treatments. The drug should be only the final alternative after other treatment options are excluded. So this bill, SB 319, utilizes public health nurses to oversee the medical monitoring of the foster youth psychotropic drug use. The duties required for the public health nurses under this bill qualify for federal match reimbursement, and it's an enhanced rate of 75% through Medicaid or Medicare. Over the last decade, the state spent more than $226 million on psych meds for foster children. Even if we can only reduce the unnecessary psychotropic drug use by 25%, the state would actually save $5.65 million annually. The bill has no opposition, and I urge an aye vote.
Thank you, Senator Bell. Members, any debate or discussion? Seeing none, members, is there any objection to using the unanimous roll call? Seeing none, ayes 40, noes 0. Measure passes. Members will now move to file item 73. Senator Bell, Secretary, please read.
Senate Bill 484 by Senator Bell, an act relating to juveniles.
Senator Bell.
Mr. President, members, SB 44 establishes the treatment protocols and institutes oversight measures in group homes. As we heard earlier, the group homes have a high preponderance of use of psychotropic drugs, and there is a concern that overuse of these psychotropic drugs is a form of chemical restraint as opposed to something that's medically necessary. Therefore, I think it's important that this bill be passed because it uses the department's existing data collection model and stakeholder working groups to develop a methodology to monitor and analyze group home psychotropic drug use. The bill further utilizes the stakeholder working groups to develop correction action plans for those group homes that are deemed unnecessarily overly subscribing to the psychotropic drug use. The bill has the same cost savings as I mentioned previously in SB 319, has no opposition, unanimous support. I urge and I vote. Thank you.
Thank you, Senator Bell. Members, any debate or discussion? Seeing none, members, would there be any objection to the unanimous roll call? Seeing none, ayes 40, noes 0. Measure passes. Members, we will now move to file item 93. Senator Monning. Secretary, please read.
Senate Bill 253 by Senator Monning, an act relating to juveniles.
Senator Monning.
Thank you, Mr. President and members. I'm honored to rise as part of the team working on the foster children and psychotropic drug issue. SB 253 strengthens the juvenile court process for authorizing psychotropic drug medication use by foster children. This bill mandates the application of healthcare standards by the judiciary when authorizing psychotropic drugs to children in foster care. No psychotropic drugs would be authorized without prior medical exams of the children, and ongoing medical monitoring must occur. For treatments with the greatest risk, a second opinion from a psychiatrist must be obtained. Members, we, the state of California, assume the role of the parent for foster youth. It is indeed the job of this legislature to be the responsible voice for those who all too often are not heard. Members, I respectfully urge your aye vote.
Thank you, Senator Monning. Members, any debate or discussion? Seeing none, members, any objection to using our unanimous roll call? Seeing none, ayes 40, noes 0. Measure passes. Members will now move back to file item 44. Excuse me, 45. Senator Galgiani. Secretary, please read.
Senate Bill 210 by Senator Galgiani, an act relating to special education.
Senator Galgiani.
Is to present SB 210 relating to deaf and hard of hearing children. Current statistics show that many children who are deaf and hard of hearing arrive at kindergarten with severe language delays and in many cases language deprivation. These children begin kindergarten without the necessary language skills to acquire the knowledge and academic capabilities which will allow them to be successful in school and life. In order to assure that children who are deaf and hard of hearing have the language foundation to enter kindergarten ready to learn, formal milestones and benchmarks must be established and monitored. The bill has no known opposition, and I'm proud to have a broad coalition of support, including the California Association of the Deaf, the California Coalition of Option Schools, and the Center for Early Intervention on Deafness. Thank you, and I respectfully ask for your aye vote.
Thank you, Senator Galgiani. Members, any debate or discussion? Seeing none. Members, any objection to using our unanimous roll call? Seeing none, ayes 40, noes 0, measure passes. Members will now move to file item 46, Senator Mendoza. Secretary, please read.
Senate Bill 212 by Senator Mendoza, an act relating to controlled substances.
Senator Mendoza.
Thank you, Mr. President. Senators, I'm here to present SB 212, which helps protect our neighborhoods and schools by allowing for an aggravated felony for the manufacturing of methamphetamine and butane honey oil within 200 feet or 300 feet, respectively, of an occupied residence or structure. SB 212 gives judges another tool to protect kids attending school and residents in their homes. Respectfully ask for your aye vote.
Thank you, Senator Mendoza. Members, any debate or discussion? Seeing none. Members, any objection to using our unanimous roll call? Seeing none. Ayes 40, noes 0, measure passes. Members, file item 47. Senator Roth. Secretary, please read.
Senate Bill 229 by Senator Roth, an act relating to courts and making an appropriation therefore.
Senator Roth.
Thank you, Mr. President. Colleagues, this should be no news to you, but we have a statewide shortage of trial judges in the state of California. To be specific, about 270 judicial positions. Some of you may recall, but in 2007, this legislature actually authorized 50 new trial judge positions in this state. Unfortunately, to date, not a single position has been funded. Senate Bill 229, as amended, will appropriate $10 million to begin the process of fixing this situation by funding 6 of the 50 Superior Court judges authorized by this legislature in 2007. The positions will be allocated in accordance with the Judicial Council's 2014 Judicial Needs Assessment. This bill is consistent with our Senate budget effort. Some of you may recall that the $10 million was included in our Senate budget proposal, which many of you voted on about a week ago. With this combined shortage of nearly 270 judges, these 6 judicial positions are a first step in meeting a critical trial judge shortage in the state of California. With that, I respectfully ask for your aye vote.
Thank you, Senator Roth. Members, any debate or discussion? Seeing none. Members, any objection to using the unanimous roll call? Seeing none. Ayes 40, noes 0. Measure passes. Members will now move to file item 49. Senator Roth. Secretary, please read.
Senate Bill 251 by Senator Roth, an act relating to disability access.
Senator Roth.
Thank you, Mr. President. Colleagues, I'm privileged to present Senate Bill 251 regarding the Americans with Disabilities Act. 25 years ago, President George H.W. Bush signed the Federal Americans with Disabilities Act, probably the most sweeping piece of civil rights legislation to be enacted since the Civil Rights Act of 1964. As you know, the ADA recognized that a majority of public facilities were inaccessible to the disabled, and the ADA sought to address this problem by requiring that access barriers be removed. From the outset, some businesses were simply not interested in complying, but for the many that were, compliance was not easy. ADA access standards were complicated, frankly, and in some cases contradictory. I suggest that if you ask a business owner, particularly a small business owner in your district, who recently received a building inspection permit, if he or she was good to go for ADA access compliance issues, that business owner would probably tell you, yep, good to go. Unfortunately, not the case. Over the past 25 years, we've spent a lot of time around here fine-tuning the ADA enforcement process, and from my perspective, not enough time educating and training business operators and owners and providing ADA access specialists to tell them what to do and when to do it and how to do it to ensure access for all. This bill attempts to address that by focusing on education, training, and access to help. So what does it do? It helps to increase the number of ADA access specialists and access to those specialists to help business, particularly small business. It requires local building departments to provide small business permit applicants with information about ADA access requirements. It provides a tax credit to help small business eliminate ADA access barriers. And for those of you who are concerned about tax credits, it has a sunset to ensure that it accomplishes its objectives. It further allows small businesses a short period of time, 15 days, to fix signage and related issues. And finally, for those businesses who are working with an access specialist to address ADA access issues, it allows those businesses 90 days from date of inspection to fix the ADA access issues before litigation for statutory penalties can begin. It does not restrict claims for personal injuries. We need to dramatically reform ADA compliance in this state with education, training, and a fair opportunity to correct. This bill is a step in the right direction. The bill received unanimous bipartisan support in the Judiciary and Governance and Finance Committees. I want to thank my colleagues on those committees for their support, and I want to specifically thank the Consumer Attorneys of California and the California Chamber of Commerce for diligently working together with me to craft this bill. I respectfully ask for your aye vote.
Thank you, Senator Roth. Senator Galgiani?
I want to thank Senator Roth for his thoughtful discussion and work on this bill. My district has been very dramatically hit by this, but I know it's a problem in many of your districts throughout the state where predatory attorneys target these businesses that don't necessarily know their rights. And oftentimes these are businesses that have really made efforts in the past to try to come into compliance, but because they have a B+ instead of an A+ on their score, perhaps a sign is the wrong color, or perhaps a bar in a bathroom is an inch too high or too low, they're being hit with these threats of being sued and fined, and not knowing how much it would cost for an attorney, they seek to just simply settle so that they don't have to go through a lawsuit. So this will go a long way to make fixes to enable businesses to stay in business. And I know in my district, for example, we have many businesses that just have simply shut their doors because they can't afford the $12,000 to $16,000 in penalties that don't even result in a fix. Those are penalties that just go toward the fees for not having a perfect score on the ADA scorecard. So thank you, Senator Roth.
Thank you, Senator Galgiani. Any further discussion or debate? Seeing none, Senator Roth, would you like to close?
Respectfully ask for an aye vote, sir.
Great, thank you. Members, any objection to unanimous roll call? Seeing none, ayes 40, noes 0, measure passes. We'll now move to file item 50. Senator Leno, are you prepared to bring this item forward? Senate Bill 252. Secretary, please read.
Senate Bill 252 by Senator Leno, an act relating to pupils.
Senator Leno.
Thank you, Mr. President. In respect of time and the number of bills that I have to present today, this bill has no opposition. It has had bipartisan support. What it will do for homeless California students, and they number about 300,000 today, to relieve them of the cost of about $150 to $200 to take a high school equivalency examination. You can imagine all of the challenges to a child who is homeless by no doing of him or herself. All the factors that may cause homelessness are long. We can give them this one benefit. In the past year, maybe 1,000 or 2,000 students did take an equivalency examination. We should make sure that $150 or $200 that they do not have in their pocket will keep them from being able to access that opportunity to higher education or to better employment. I ask for your aye vote.
Thank you, Senator Leno. Members, any debate or discussion? Seeing none. Members, any objection to using a unanimous roll call? Seeing none. Ayes 40, noes 0. Measure passes. We'll now move to file item 51. Senator McGuire. Secretary, please read.
Senate Bill 288 by Senator McGuire, an act relating to vandalism.
Senator McGuire.
Thank you, Mr. President. This is one of Mr. Wachowski's favorites. Honored to be able to present Senate Bill 288, California's majestic old-growth redwood trees. The tallest trees on the planet are being targeted at an increased rate by poachers seeking to make an easy profit. These criminals are going into our state and national parks and cutting out the valuable hardwood from the old-growth redwood tree. A redwood burl grows from the base of each tree and allows the tree to be able to grow new branches, roots, and propagate. And a burl produces marbled hardwood that, when cut and polished, has a beautiful luminescent appearance. And depending on the size of the burl, it can be used to make anything like trinkets of salt and pepper shakers to tables. And while some burls are small, many weigh hundreds of pounds and fetch tens of thousands of dollars on the black market. Only 5% of the remaining old-growth redwoods still stand in this great state. And since the 1840s, 95% of old-growth redwood forests have been cut down. And today, only 120,000 acres of ancient coast redwood forests remain. Burl theft was at an all-time low about 7 years ago, when we only saw 4 cases reported. However, burl theft is now on the rise, particularly on the North Coast, where the vast majority of these old-growth redwoods remain. 14 cases in 12, and it's been increasing ever since. And between 2010 and 2014, we've seen 106 incidents in redwood state and national parks, where taxpayers spent over $1 billion to be able to preserve. SB 288 will give local district attorneys the tools they need to prosecute these senseless crimes and go after the poachers. I respectfully ask for your aye vote.
Thank you, Senator McGuire. Members, any debate or discussion? Seeing none. Members, any objection to the use of the unanimous roll call? Seeing none. Ayes 40, noes 0. Measure passes. Members will now move to file item 52. Senator Mitchell.
Mr. Secretary, please read.
Senate Bill 443 by Senator Mitchell, an act relating to forfeiture.
Senator Mitchell.
Thank you very much, Madam President. Colleagues, I know we have a long agenda today, and I'm, along with you, have tried to be very brief in my statements. I'm going to take a little longer than I normally do on this one, only because so many members have asked specific questions about this issue, and so I want to try to cover all of them in my statement, so I hope that you will indulge me. Again, I'm presenting Senate Bill 443, a bill to protect California property owners from abuses in civil asset forfeiture and to ensure that law enforcement engaging in civil asset forfeiture is subject to California state laws. This is a multi-pronged approach to a problem which has reached epic proportions in many California communities, requiring that in most cases a defendant be convicted of an underlying crime before cash or property can be permanently seized. It will require that more drug asset forfeiture cases be handled under state law rather than transferred to federal courts in order to ensure the stricter standards under California current law are followed. Frankly, colleagues, I have been blown away at some of the stories and statistics I've read concerning the practice of civil asset forfeiture. Stories that have run in the Orange County Register, the Press Enterprise, the Washington Post, just as recent as today, as well as other periodicals across the state and nation. The idea that law enforcement can permanently seize a person's assets with no conviction, with the onus on the accused person to prove their own innocence has been shocking. The calls to address this problem have been from both sides of the aisle and from officials at both the state and federal level. Case in point, national bipartisan call for reform. A national bipartisan consensus has emerged for an end to equitable sharing. On January 9th, 2015, the Republican chairs of both the U.S. Senate and House Judiciary Committees wrote to former U.S. Attorney General Eric Holder asking that the U.S. Department of Justice end the practice. They wrote, permission to read, Madam President?
Without objection.
Thank you. And they wrote, quote, "We are concerned that these seizures might circumvent state forfeiture restrictions, create improper incentives on the part of state and local law enforcement, and unnecessarily burden our federal authorities." On the 16th, former Attorney General Holder announced new guidelines to limit equitable sharing, in addition to the concerns raised by Congress. The U.S. Department of Justice decision follows hard on the heels of a Washington Post investigation called Stop and Seize that found that since 2011, police have made cash seizures worth more than $2.5 billion from motorists and others without first obtaining search warrants or indictments. In California alone, colleagues, in the 8-year period between 2000 and 2008, California law enforcement entities seized over 300 million, the paper is here someplace, $300 million in assets. Again, a recent editorial by former U.S. Department of Justice officials appointed during the Reagan administration wrote, again, permission to read?
Without objection.
Quote, "As two people who were heavily involved in the creation of the asset forfeiture initiative at the Justice Department in the 80s, we find it particularly painful to watch as the heavy hand of government goes amok. The program began with good intentions, but now, having failed in both purpose and execution, it should be abolished," end quote. Unfortunately, the U.S. Department of Justice decision to limit equitable sharing is not a permanent statutory change and can be reversed by a subsequent administration. Therefore, states must provide durable protections through legislative reform. Hence, the bill I'm bringing before you today. What this bill specifically will do: it addresses the issue of equitable sharing with the federal government, which results in California cases not adhering to California laws. It increases protections for California property owners by requiring a conviction if property is to be taken permanently. It gives people who have had property seized the right to an attorney. The right to an attorney is currently guaranteed under criminal law, not so under civil law. It allows for recovery of attorney's fees if the person is found innocent of the crime they were accused of. It also shifts the onus from the person having to prove their innocence to law enforcement to prove guilt. It increases transparency. Current law requires the Attorney General to issue a yearly report, which this bill builds upon to include the number of cases initiated under state law versus those involving the feds, the number of suspects charged with crimes, the disposition of the cases, i.e. if no charges were filed, if the charges were dropped, a plea deal, acquittal, etc. It adjusts the distribution of seized funds in such a way as to take the incentive off the table for local law enforcement to focus an excessive amount of its energy on asset forfeiture. Simply, members, SB 443 reestablishes the most basic tenets of California constitutional law and values and ensures that California state law is being adhered to. Amendments were taken in the Appropriations Committee to restore funding for the ethics training relative to asset forfeiture. Again, under the current practice, the distribution of forfeiture proceeds go according to this percentage breakdown. 65% of asset forfeiture proceeds are distributed to law enforcement, 10% to the prosecuting agency, 24% to the general fund, and 1% for training of prosecutors on asset forfeiture. And according to the annual Attorney General's report, most counties give that money to the California District Attorneys Association. because this bill could result in increased court time in forfeiture actions and would require additional indigent defense resources. This bill would reallocate the proceeds from forfeitures to ensure that courts and court-appointed counsel receive additional funds to cover their increased costs. Therefore, this bill would have a distribution formula that looks like this: 54% to local law enforcement, 24% to the general fund, which is no change, 10% to the courts, 5% to prosecutors and 5% to defenders, and 2% for ethics training for asset forfeiture practices. Again, those are the amendments we took in appropriations. I ask for your support for this very critical policy change, which will allow law enforcement across the state of California to focus on California's state law versus expanding and extending their power in accordance with what the federal government will allow.